Thank you. I appreciate the opportunity to address you. I'm from Elk Rapids. I'm an attorney and a professor of political science at Grand Valley State University. First, congratulations on addressing this issue. In looking at the policy, to me the first consideration is the stated purpose of the enactment. In this case, it is providing all students with a safe and supported school environment. Is this in fact the purpose? And if so, then the bullying prohibition should address any and all types of and reasons for such bullying without exception. My question is, does the policy as written effectively accomplish this? It appears to me that the proposed TCAPS policy reflects the anti-discrimination policies common in the workplace. There are several problems with taking this approach. The first is that the Supreme Court has recognized that there are activities common to and tolerated in the school setting that would not be tolerated in the workplace. You're mixing apples and oranges when you do that. The second and far more important reason is that while workplace discrimination is sometimes allowed and only illegal for other purposes, school bullying should be prohibited in all circumstances, at all times, and for all reasons. For example, some workplace discrimination is not only legal, but it's necessary. Other discrimination, such as that based on immutable or other recognized and protected characteristics, is illegal. So discrimination based on race, gender, marital status, national origin, religion, and in some cases weight and sexual orientation is generally prohibited in the workplace. However, discrimination based on education, training, licensing, relevant physical ability, and in some cases even gender, is legal if such discrimination bears unemployment requirements. While some workplace discrimination is legal and allowed, bullying is never acceptable, and it is a mistake to mix employment-based law models with their specifics into a school anti-bullying policy. Here's one reason why. The proposed policy specifies other prohibited conduct in Section 2E to be conduct based on workplace-type laws relating to race, color, national origin, sex, disability, age, religion, height, weight, etc. You all know the policy. Is that to suggest that unacceptable conduct based on other characteristics is not bullying? That was brought up earlier by one of the speakers here. I would suggest that clothing, perhaps related to family economic circumstances, is a candidate for bullying. Others are the inability to secure a date for the big dance, driving the wrong kind of car or no car at all, missing the last shot that loses the big game, having the wrong type of parent, or not having the latest electronic device. We all know that the adolescent mind is endlessly creative in finding reasons to pick on and bully their peers. So the list is endless. But under the proposed policy, is bullying only bullying if it is based on the express reasons in Section 2E? Now, as I think you all know, an apparent answer to this question is that Section 3 specifies other prohibited conduct. And one can assume that this is the catch-all paragraph that takes in all the other foundations for bullying, including the list above. Will this work? By analogy, I want to point out, when the Bill of Rights was being added to the Constitution and being debated at the conventions, there was the concern that by listing the protected liberties, others would be assumed not to be protected. And so
30 seconds.
The Ninth Amendment was added to it. In that Ninth Amendment, it called up all other liberties that weren't named. That has led to a spate of Supreme Court cases that doesn't end, including whether privacy is included. If the interest of this board is to prohibit all bullying, that in the words of the Supreme Court, deprive the victims of access to educational opportunities or benefits provided by the school, or in the words of the policy, provide all students with a safe and supportive school environment, then I suggest the best way to do that is prohibit all forms of bullying, which is the action that causes the harm. That's the thing you should be addressing. What is the action, not the reason? In criminal law, you prohibit robbery, not robbery based on certain reasons. Bullying is the same way. And I would suggest that taking any other approach is simply inviting litigation and not protecting your students to the extent that you could. Thank you.